Hello, my name is Hina Farooqi, and I'm an associate lawyer practicing family law at Bozai Law Professional Corporation. Today, I'm here to talk to you about one of the most common issues that arise during separation: who gets what property. This video discusses property division for common law, not married couples. If you were married and are now separated or divorced, you can check out my video on property division during a divorce on bozailaw.com. In a lot of family law areas, such as child support and spousal support, common law couples have the same legal rights as married couples. This is not the case when it comes to property division. Married couples usually share the value of their property if they separate or divorce. Common law couples have different rights. Usually, each common law couple keeps the property they had when they started the relationship and the property they got while they were living together with their partner. They only have to share the property that they own together. For example, say you and your partner have 3 bank accounts: one that you own with $5,000, one that your partner owns with $4,000, and one that you own jointly with $12,000. When you separate from your partner, you keep your $5,000, they keep their $4,000, and the $12,000 is divided equally. Usually, you're responsible for paying your own debts, and your partner is responsible for their own debts. You're both responsible for repaying a debt if you signed a loan agreement together. This is true for any 2 people who sign a loan agreement together, whether or not they are married. Even if you did not benefit from the loan, you might have to repay it if your partner doesn't pay. Of course, not all property is as easy to divide as a bank account. The biggest one will be if you owned a home together and were both on title for the property as joint owners. Your main options will be either to buy out your partner, or you can sell the home and split the money. There are some exceptions where you can make a claim to property that is in your partner's name. The most common example is by proving what's called an unjust enrichment. This means that it would be unfair to allow your partner to leave the relationship without sharing their property. To make this claim, you have to show 3 things. 1, that you contributed to the property. 2, that your partner benefited from your contribution. And 3, that there is no reason for your partner to keep this benefit for themselves. You may have made a direct contribution to the property. Some examples include: you paid for a new roof on the house you owned but your partner owned, you built a deck on the house your partner owned, or you managed all the bookkeeping for your partner's business. Or you have made an indirect contribution to the property. Some examples of this are: you cared for the children and the home, which allowed for your partner to spend time growing their business, or you paid all the household bills and your partner put all their money into savings. If you can show an unjust enrichment claim, you don't always get half the value of the property. The law considers what your fair share would be. Usually this can be paid by money. Sometimes, if money is not enough, you can be given a direct interest in the property you contributed to. For example, the court may order that you own 1/3 of the house and your partner owns the other 2/3. Another claim a common law partner can make is that their partner is holding property through a resulting trust. This means that the property is in your partner's name, but it's really your property. Claims based on unjust enrichment and resulting trust can be very hard to prove. You may wish to consult a lawyer about your chances of falling into one of these exceptions for property division. You may also wish to consult a lawyer to help you come to an agreement about who gets what property without having to prove your claims in court. If you and your partner cannot agree, you can ask the court to make an order to divide your property. There is a time limit to make a claim for a share in property that is not real estate, such as a claim for a share in a business or a car, and that is 2 years after the separation date. The usual time limit to make a claim for a share in real estate is 10 years after you separate. If you have any further questions about common law separation, call one of our lawyers today at Bozai Law or visit bozailaw.com.